All right.
Okay.
I'll just go ahead and just pretend like we're live. But again, as I've said many times before, you've done this before. If we need to go back and edit in the post, I can do that.
Gonna get that centered a little better. And I'll move over with my props. That's good. I hate having the tree right behind my head. That's never good.
No,
To be
no,
like,
no, no,
to be like this, with the
yeah.
not good.
No, we don't need that. We don't
No,
need that. No, it's
no.
it's nice and centered now.
Yeah. So, but I'll even put this here for starters. Okay.
Okay, I love
How's
it.
that?
Yeah, perfect. Also, I love a lot of the blue that we've
Yeah.
incorporated here. So,
Yeah.
okay.
That's me.
All right. Okay. Each June delivers some high profile decisions from the United States Supreme Court. One notable case this year is Vidal versus Elster, where the court rejected an attempt to force the Patent and Trademark Office to accept the registration of Trump Too Small as a trademark for t-shirts mocking the former president. In today's episode, we are joined by Professor Yvette Liebesman to discuss the case, the decision, and the implications going forward. Professor Liebesman is an expert in patent and trademark law and is the faculty advisor for the law school's intellectual property concentration. Thank you for joining us today.
Oh, it's my pleasure. This is an interesting decision by the Supreme Court.
Yes. So let's start with the details of the case. It originated from back in 2016 when Senator Marco Rubio's infamous taunt regarding the size of then candidate Trump's hands, to be clear. What is the argument that was made regarding the trademark of the shirt? And
Okay.
actually, I know that.
So
Yeah.
Elster
Mhm.
decided to make T-shirts that said Trump too small.
Look at that.
And the back talks about what he's too small at.
Oh my.
Yes.
Oh. Uh-huh.
Yeah, a lot to it. So these are just slogans, and slogans can sometimes get registration. Think when they're attached to a brand. Think of Nike, just do it.
Mm-hmm.
Think of there's I had my Amarin bill here for a minute, and it had a slogan on it.
Mm-hmm.
So you have these things that have slogans that are attached to the actual brand, and we can think of lots of those out there.
Right.
But slogans like Trump too small, it's not attached to any sort of brand. So trademarks protect brands. And
Mm-hmm.
so, but what that's not what Mr. Elster was trying to do. What he was doing instead is he named his company Trump Too Small and was trying because that's
Okay.
the source of the goods now is the company Trump Too Small. That's what he was trying to get registered, not the
Oh.
slogan on the shirt. So
Yeah.
there's lots of things you can register, lots of things you can't. So what he was saying when he was denied registration was that, wait a minute, this is infringes on my First Amendment rights because this is an unconstitutional restriction based on content. That you're
Mm-hmm.
restricting me based on content because there's a section of the Lanham Act. The Lanham Act is what we call the federal trademark law. Nobody calls it the federal trademark law. You call it the Lanham Act. So Lanham Act says that you can have a mark, a trademark, in any word or symbol or name or device or combination. Lots of things can be marks, and I'll show some examples in a bit. But then it also lists things that you can never get registration for. Some
Mm-hmm.
things like if it's a useful article. So, for example, here I have a water bottle and this water bottle has this really cool spitsy thing on it.
Right.
I can't say, oh, this is my mark. You recognize my water bottle based on the spitsy thing. That's a functional thing. And you
Mm-hmm.
can't stop other people from making functional things. You
Mm.
also can't register generic words as the thing. So I can't have a brand strawberry for selling strawberries.
Okay.
I can have a brand Apple for computers. That's called an arbitrary mark. So we have
Uh-huh.
lots of things we can have marks, but lots of things that the law says no, you can't. And one of the things it says is that if it's a living person, if it's named after a living person, and Elster always said this was after Donald Trump, this is all about
Mm-hmm.
Donald Trump. It's not using Trump in any other fashion that um, Section 2C says that if it's the name of a living person, you can't use it without consent. So, for example, I'm going to share the screen for a sec.
Okay.
Here is Taylor Swift register. And if we look at the very bottom, it says she has consented to register her name, that
Mm-hmm.
the portrait or signatures shown on the mark and everybody whose consent to register is made of record. Donald Trump didn't do this. And so, and here's another one for Beyonce, same thing.
Uh-huh.
Consent is on record. So that is what um, Elster needed to do if he wanted registration for his mark. Okay. So he didn't get it, obviously. And it wouldn't matter if it said Trump too small or if it said Trump forever. You still need Donald Trump's permission in
Mm-hmm.
order to get registration in a mark that uses his name for him. And Elster was claiming, wait a minute, just like in the case of uh, Metal v. Tam, where the
Mm-hmm.
court said disparaging marks, which had originally you couldn't get registration for those. No, that's viewpoint. That's viewpoint discrimination, and that violates the First Amendment. And they did the same thing with the case called Ianco versus Brunetti, where it was rejected for being an offensive word mark.
Mm-hmm.
They said, no, that's viewpoint discrimination, and First Amendment prohibits that. You have to let offensive words be registered.
Mm-hmm.
And so Elster was trying the same thing with names. And he
Mm-hmm.
said, this also First Amendment. And what the court here said is, no, this is different. This isn't content based. This isn't a viewpoint restriction. This is neutral. This is content neutral. It's viewpoint neutral. It's got nothing to do with what you're saying about the person. It's got to do with you're using the person's name without consent.
Right.
And they said that doesn't violate the First Amendment. While they were unanimous in saying that, there was about 4 different reasons.
Mm-hmm. Mm-hmm. And I have lots of questions about that one.
Sure.
Before we move on to that though, I kind of what you're talking about. So what would be the difference if, well, first I find it crazy that considering Trump has all these companies with his name on it, that his own name in fact is not registered, but
It could,
okay.
well, it
And
probably is. I didn't look. I'm
oh,
sure
okay. I was like,
I'm
that's
sure I
crazy.
could find plenty if I took a minute to look.
Okay,
Um,
okay. I was like, wow.
would you want
And
to
then,
pause? Do you want me to bring one up and we can
oh,
edit this?
no, 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 that's okay.
We'll edit this
Because
part
what
out anyway that I'm talking right now to say, well,
that's okay. All right. So when, as you're saying, the court had this unanimous decision, and we had a bunch of different opinions that were pretty varied. So, like in the concurring opinion, the main opinion was written by Thomas, right? Okay. And then in the concurring opinion, Justice Sotomayor argued that the trademark would not offer the holder any additional benefit and does not prevent Elster from speaking or selling objects. Which I kind of thought was the most
well,
reasonable one.
there were actually 3 other concurring opinions.
Yeah. Mhm.
So
Oh, I know, right?
Thomas, oh yeah, Thomas's was totally based on history,
Mhm.
and that viewpoint neutral has always been the way. And he really tried to make it all about the history of trademarks going back to wherever. And we've
Mhm.
always said you can't use somebody's name. And so he was really, really into the history.
Yeah.
Okay. And then Justice Kavanaugh and Chief Justice Roberts, they concurred, and they said that it was constitutional based on historical evidence. But they said, well, you could just say it's viewpoint neutral, and that would do it without, you don't have to use any of the history to do that.
Mhm.
Then Justice Barrett stepped in, and she also agreed. And actually, Justices Sotomayor and Justice Jackson also concurred in this part,
Mhm.
saying that she was basically like, "Why are you even talking about history? We don't
Yeah.
need to talk about history to solve this."
Uh-huh.
Um, Basically, it's the whole point of trademark is to protect the brand and to keep customers from being confused. And if they see someone's name attached to it, they are likely going to associate that person with that mark, and
Right.
it's false. So she was basically very upfront and saying we shouldn't even be relying on history. And um Justice Sotomayor also said something similar. She said that it really should be about our precedents and not using this whole history and tradition thing that Thomas said, but just go by our precedents. And there's plenty of precedents on the record for us to be able to make this decision without going into anything else.
Right, right.
Justice
And
Barrett was more about, she basically kind of said, we're going to hit a point where you're not going to be able to find history on something. And so stop trying to like shoehorn history into this when it's not necessary, because when are you going to stop trying to shoehorn history?
she really like hammered home on
Yeah.
that one. I
She's
noticed.
like, yeah, she went over, not over, she really went after him for the history nonsense. You can tell she's really getting fed up with the history.
Yeah, she's getting a little fired up.
Yes.
Yeah, because I also thought, and like to what Sotomayor had said, is like, I didn't really see, like, even if it wasn't a trade, he can still sell it. Like, it doesn't,
Yes.
right.
He
So
can
I don't
still
really
sell
see,
it.
how do we get this far, I guess?
Well, I think it was kind of important because we had Tam and we had Brunetti, and they were both First Amendment issues.
Mhm,
And, the USPTO, the trademark office said, no, it's not registerable for, because it's a name. You need to get the person's permission if you're using someone's name.
mhm,
And this is not you're using their name and there's a false designation, and it went through the courts and it kept going on. And I think they really wanted to make it quite clear that um this was registerable, um
mhm.
was not registerable,
Right,
which I
right.
find kind of interesting, because there was a whole bunch of marks back around 2015, 2016 that
Mhm.
used Secretary Clinton's name,
Yeah.
and she filed opposition, and they were all like, no, this is good.
Huh. Huh. You find that interesting, but not surprising, right?
Yeah. And one of them was Citizens United, not timid, to tell the world what Hillary Clinton really is.
So that was like a slogan, or that was the name
Yeah,
of the
think
company?
of the first letter of Citizens United, not timid.
Oh,
And then underneath
no.
it said, telling the world what Hillary Clinton really is.
Oh, no.
Yes. And that was fine.
Well, as we've discussed, um, it, not
I think it was
vulgar, but
interesting
the
because
bad
one,
words are not
yeah,
bad.
yes. But they used Hillary Clinton's name. But I
Yes.
think your argument there was that nobody would ever think she was associated with this.
Right.
And
Right.
so that's how that one went through, is they said no one would ever think she's associated with this.
I get, yes, yes. But then would people think that Trump was associated with saying anything too small? I feel like he's the opposite of small in the way that
Um,
he tries to present himself, right?
I think I think that this is the only way this was a good case to decide that names in general, you need permission.
Mm-hmm. I
It's
guess
a
that's a
living
good
person.
way to segue into my next question, which is what kind of implications does this decision have on trademarks and I guess the First Amendment as well going forward?
Well, I think what it says is that we're talking about something that is content neutral. It doesn't matter if it's Trump too small or Trump president forever. And
Mm-hmm.
one, there's if it's a slogan, doesn't even involve trademark law. If it's
Mm-hmm.
the name of the brand, if it's using it as the name of the brand, you need the permission of the living person in order to do that. And it doesn't matter, as long if you're using it as a brand, you need their permission regardless of how it's being used. And I think the fact they really said it's all about protecting consumers from confusion as to the source of the goods.
Right. Right.
So we know this is Starbucks. I
Right.
know the quality of the coffee in here.
Mm-hmm. Mm-hmm.
That is, we have brands that tell us these things.
Mm-hmm. Mm-hmm.
That's the purpose. I have my Dull pineapple juice. Okay.
Mm.
Dull, I expect a certain quality out of
Right.
it.
Right.
So this is all about protecting brands, and I'm not going to be fooled. Someone can't come along and call something Dolo and replace the E with an O and have it looking the same. And I'm
Uh-huh.
confused and I think it's dull when I'm not buying dull. It's to protect the consumers from confusion as to the source of the goods.
So, right. So it's beyond, when you first look at the case and you see the subject of the trademark request, you're thinking it's like, it's a little bit political, but really what you're saying is it's really more about the crux of it is not about Trump. It's about
It's
brand
about using
protection.
anyone's name
Uh-huh.
as the company, as the
Mm-hmm.
source of the goods. It's
Mm-hmm.
not about what's on the t-shirt. It's about who the manufacturer is. What is the brand? It's this thing here that's the brand that was being litigated, that was being
Mm-hmm.
disputed, not what was on. And that's where
Mm-hmm.
Sotomayor, he even happens to keep selling the shirts. Nothing
Yeah.
stopping them.
Yeah.
Nothing stopping them from selling the shirts, even using this as the brand name, but you're not getting registration for it.
Mm-hmm. Mm-hmm.
So,
I love that you have it. I really love
of
that you have
course.
it. It's like a collector's item now, yeah?
Oh, you can still buy them.
Oh, you can?
Yeah, this didn't stop them from being sold. This just stopped him from registering the mark, which
Right.
there's a couple things that it helps with, and one of them is, so if you know somebody in France who imports these counterfeit T-shirts into the country, then
Mhm.
they can't stop them at the border, but Elster can sue them for infringement.
Mhm. Okay.
Yeah.
Well, that certainly is interesting. It's definitely not when you first brought this case to my attention and I started looking at it. This is not the way I thought it would all pan out. So I appreciate taking the time to break it down.
Oh, you're
Um,
welcome.
Thanks for joining us
Oh,
today
my
and
pleasure.
for letting us see all of the wonderful trademarks. Oh wait, you had one more thing. Didn't you have some sort of bottle of something?
Oh, yes. So
That blue
lots of
thing?
things can be marks
Yes, let's see.
and lots of things. So colors can be marks. Like this is
Mhm.
Tiffany. Shapes that are not functional can be marks. So I have this empty bottle of alcohol, and it's
Okay.
got the dog head, and there's nothing functional about the shape or having it look like a dog
Uh-huh.
that makes it useful, that,
Mhm.
it's so this is actually what's called trade dress. Okay.
Okay.
Similar to, we have Mrs. Butterworth. Okay. The shape,
Mhm.
it's not functional. There's nothing functional about the bow on her back.
Mhm.
Okay.
Mm-mm.
That is, but we recognize the shape as Mrs. Butterworth's original syrup. And notice it does not say maple. Um,
No, it sure doesn't. It's just sugar water. I
yeah.
will say that, so I guess, I'm going on a tangent, but I feel like there are certain off brands, right? Like particularly around the Mrs. Buttersworth, where they use a little bit, the bottles are similarly shaped, but there must be something that's just a little bit different, right? In order to make it legal. Like
Well,
I'm just thinking about like the generic store brand, right?
well,
That
the
has,
generic store brands are allowed to be a functional shape,
okay.
but you can't have it look like Mrs. Butterworth. And a lot of this has to do with, there are these factors they look at to see whether something is too close and is going to cause confusion.
Mm-hmm.
So if you had a bottle and you're looking at the backside and they look the same, that's going to get you into trouble.
Mm-hmm.
Uh, but brands, there's a lot of overlap. You can use the same name, and you can use certain words that you can't get a monopoly on. So for
Mm-hmm.
example, if it's, log cabin syrup, when they register that, they have to actually say, but we're not going to claim syrup by itself or log by itself or
Mm-hmm.
cabin. We're only going to claim the whole phrase.
Okay.
Also, so I have my EOS lip balm here.
Uh-huh.
There's also an EOS camera and an EOS car and EOS wine. Nobody is going to be, even though EOS you think is a not very common word, but
Right.
I'm not going to go into Walgreens to buy a car.
No.
Just like
Wouldn't that be
Delta.
funny?
Yeah, you have Delta Airlines and Delta Faucets,
Yeah.
and you don't buy airline tickets in the plumbing section of Home Depot.
Uh-huh.
So you can
Uh-huh.
have the same names as long as it's not used in a confusingly similar way.
Okay. And all of this is now essentially protected a bit further from this decision, is what you're
Yeah.
saying. Okay.
It's well, it's not going to affect any of these things. It
Mm-hmm.
affects, like, nobody can use Taylor Swift in their brand without her permission. And you saw
Mm-hmm.
when I brought up that registration, it said point blank, they have her consent on file for this
Mm-hmm.
use. Same thing
Mm-hmm.
with Beyonce's. If I were to bring up ones for that Donald Trump had registered, maybe Trump Wine or Trump Steaks or Trump University, they all
Mm-hmm.
would say that he has approved this.
Mm-hmm. Mm-hmm. Well, well, well. Now I'm probably gonna spend the rest of the afternoon trying to find Donald Trump's patent. So
Patents? You mean trademarks?
I mean trademarks. Trademarks too. All right. Well, I'm glad I have you here to clarify everything for me.
Oh, my
I
pleasure.
appreciate
It
it.
was an interesting case. And
Yes.
yeah, it really was. And, you can still buy your Trump Too Small shirt.
There you go. We'll all have to find a day to wear it together. I know, a perfect day. It could be perhaps in November.
Yes, maybe like November 5th.
Yes. All right. Thank you so
You
much,
can't wear
Yvette.
it to a polling place, though. You're not allowed to wear campaign
Oh,
things to a polling place.
noted. Noted. All right. Well, thank you so much.
Oh, my pleasure.
Okay.
Bye.
Bye.